It's a real pleasure to welcome everyone here today. I would like to acknowledge the presence of Mr. Schmale, who is replacing Mr. Falk, and also the presence of Mr. Mulcair, replacing Mr. Rankin, and Ms. Vandenbelt, who is replacing Mr. Hussain. Very pleased to welcome you all to our committee.
Forward to your questions later. And now it also gives me great pleasure to welcome the Honourable Jody Wilson-Raybould, the Minister of Justice and Attorney General of Canada, who is now testifying before this committee for, I believe, the 4th time. As always, Madam Minister, it's an incredible pleasure to have you. And we're going to be talking today about the process for appointing justices to the Supreme Court of Canada. Madam Minister, the floor is yours.
Well, thank you, Mr. Chair, and thank you to the members of the committee, many of whom look a bit tan. So I appreciate that this is summer. Again, I'd like to thank everyone for convening today in August. I recognize that it is summer and that this means that you're being pulled away from your ridings and perhaps some personal plans, but I greatly appreciate the opportunity to be able to speak with all of you about the government's approach to the Supreme Court of Canada appointment, the new selection process that we have outlined on August the 2nd. So as you know, the Honourable Justice Thomas Cromwell will be retiring on September the 1st of 2016, creating a vacancy that we are aiming to fill in this court's fall session. As stated in my mandate letter, the Government of Canada is committed to a Supreme Court of Canada appointments process that is transparent, inclusive, and accountable to Canadians. One that includes engagements with all parties of the House of Commons, as well as consultation with all relevant stakeholders, and that ensures those appointments to the court are functionally bilingual. My aim today is twofold. First, to outline the new process to you, detailing how it encompasses these and other fundamental values. And second, to hopefully hear the committee's views and perspectives, given your experience and expertise. Before continuing, I want to emphasize the great sense of responsibility with which our government approaches the Supreme Court of Canada appointment process. This committee knows well the Supreme Court is an essential pillar of Canada's constitutional architecture. As the final court of appeal on all legal questions, including constitutional questions, the Supreme Court plays a pivotal role in promoting respect for the fundamental rights and the rule of law. The way we select judges to the Supreme Court is therefore of the utmost importance. Enhancing the credibility of the appointment process will bolster Canadians' confidence in this fundamental institution. The appointment of the Supreme Court, or the appointment of a Supreme Court of Canada justice, is one of the most important decisions the Prime Minister makes. The top court's decisions affect us all. They influence our economy, our cultural mores, and our definition of individual and collective rights and responsibilities. Throughout our history, we have most often found and been served by the very best within our legal community. But the process used to appoint Supreme Court justices is opaque, outdated, and in need of an overhaul. We believe that Canadians deserve consistent, rigorous processes that are transparent, inclusive, and set a high standard for accountability. I wish now to briefly describe how these three important values, transparency, inclusiveness, and accountability, play out in the new selection process. I will then note two other factors that are equally crucial, namely the need to safeguard judicial independence and the desire to identify jurists of the highest caliber who represent the diversity of our country. A transparent process is one that is clear, open, and easily understood. This requires a clear public explanation of how the process is to operate. We have therefore provided not just a detailed description of the various steps in the process, but also information such as the criteria used to assess candidates and the identity of those doing the assessment. Last week, we posted this information online so Canadians can know and understand how and on what basis the next justice will be selected. My appearance before you today is another example or important part of this effort to publicly explain the process and to ensure it is clear to all. Transparency is also a prerequisite to accountability. If the process and the criteria for decision-making are not publicly known, it is difficult to hold decision-makers to account for the exercise of their responsibilities. As such, this process is designed to be open, transparent, and based on established and publicly available criteria. As I will make clear later in my remarks, you, as members of the Justice and Human Rights Committee, will play a crucial role in holding the government to account both for its selected nominee and for its adherence to an established process. An inclusive process is one which ensures the widest range of candidates from the broadest variety of backgrounds is available for selection. It is a process characterized by outreach and engagement. The goal of inclusivity must be reflected in matters such as the manner in which the initial list of candidates is generated. Further, an inclusive process avoids criteria or procedures that can hinder individuals from traditionally underrepresented groups from receiving fair and equal consideration in the process. A further value is the need to safeguard judicial independence, a requirement flowing from the Constitution itself. Judges must be and be seen to be fair, impartial, and open-minded, and not beholden to any particular group or interest. Supreme Court justices must in no way be seen to be indebted to or dependent on those who selected or appointed them. The role of an independent, nonpartisan advisory board, which I will describe shortly, advances this principle. Further, the selection process must safeguard the integrity of the Supreme Court and the judiciary in general in order to maintain public confidence. Care must be taken to avoid a process that inadvertently undermines the judiciary as an institution or the reputation of individual judges. This requires, for example, that the confidentiality of applicants be respected and preserved by all those involved in the process. The selection process must be designed to identify individuals with the highest degree of professional excellence and personal suitability. Assessments of candidates must be based on objective criteria that set out the professional capabilities and personal qualities needed to serve effectively as a justice of the Supreme Court of Canada. To this end, consultations and decisions at all stages of the selection process will be guided by assessment criteria that have been published on the website of the Office of the Commissioner for Federal Judicial Affairs, and which I will review later in my remarks. Canadian society is rich in diversity, and this has important consequences for the selection process. Justices of the Supreme Court of Canada must be able to adjudicate complex legal questions affecting those with a wide variety of experiences, backgrounds, and perspectives. For this reason, one of the assessment criteria is the ability to appreciate a diversity of views, perspectives, and life experiences, including those related to groups historically disadvantaged in Canadian society. Diversity within the Supreme Court itself is important for two main reasons. First, bringing together individuals with various perspectives and life experiences enriches the collegial decision-making process of the court. Second, a Supreme Court that reflects the diversity of the society it serves enhances public confidence in the court. The assessment criteria therefore require that candidates be considered with a view towards ensuring that members of the Supreme Court are reasonably reflective of the diversity of Canadian society. The selection process that I will now describe is designed to concretely embody these values and objectives. At the heart of the process is an independent, nonpartisan advisory board tasked with identifying suitable candidates for appointment. The 7-member board is chaired by former Prime Minister Kim Campbell, also a former Justice Minister and Canadian Consul General, and currently the founding principal of the Peter Lougheed College at the University of Alberta. The board also includes 4 members nominated by independent professional organizations. These are Richard J. Scott, former Chief Justice of the Manitoba Court of Appeal and currently counsel in a Winnipeg law firm. He was nominated by the Canadian Judicial Council. Susan Ursel, a senior partner with a Toronto law firm who also provides legal research support to Envisioning Global LGBT Rights, nominated by the Canadian Bar Association. Jeff Hirsch, President of the Federation of Law Societies of Canada and partner in a Winnipeg law firm, nominated by the Federation of Law Societies. Camille Cameron, Dean of the Schulich School of Law at Dalhousie University and President of the Canadian Council of Law Deans, nominated by the Canadian Council of Law Deans. The advisory board also includes 2 government-appointed non-lawyers chosen for their outstanding community leadership and involvement. Stephen Kathwe, former Premier of the Northwest Territories and President of the Dene Nation, and currently working to improve the recognition and realities of Indigenous peoples within Canada. Liliana Pereza, President and Executive Director of Senstrate of Greater Montreal. We believe the involvement of respected stakeholder organizations is important to ensure objectivity and independence of the process. Representation from the legal community on the advisory board provides critical input into assessing the professional qualifications of candidates. The lay members provide valuable input and help bring diversity of views to the advisory board's deliberations. Unlike earlier processes, the advisory board will not take as its starting point an initial list of candidates proposed by the government. Rather, it will consider individuals who have submitted their candidacy through an open application process. The open nature of this process is unprecedented. To ensure as broad and diverse a pool of candidates as possible, the advisory board may also proactively encourage outstanding candidates to apply. Indeed, for the public who may be watching, I encourage you to identify and encourage qualified candidates to put their names forward. I will continue to repeat that message in all different forums. Further, the application process will be open to Canadians from across the country. The government is mindful of the important custom of regional representation and values the importance of regional diversity on the court. The Prime Minister has specifically asked the advisory board to provide a list of 3 to 5 qualified and functionally bilingual candidates that includes candidates from Atlantic Canada. In making that selection, he has asked that the board consider the custom of regional representation on the court. In assessing candidates, the advisory board will be guided by assessment criteria that have been made public, as I said, and by our government's commitment to ensure that the Supreme Court nominees are functionally bilingual. As part of the assessment process, the advisory board will consult with the Chief Justice of Canada and any key stakeholders that the members consider appropriate. I expect the board's consultations to be wide and fulsome. While the objectives of openness and transparency will inform all steps of the process, current aspects of the process, such as the deliberations of the advisory board, will remain confidential. This protects the privacy interests of candidates and allows for full and frank discussion of all candidates. To promote transparency, the advisory board will provide a report to the Prime Minister within 1 month of the vacancy being filled, outlining information about the process, including statistics related to applications received, the manner in which the board executed its mandates, and the costs associated with the process. This report, which must be made public, may also contain recommendations to improve the process. Upon concluding its assessment, the advisory board will submit a short list of 3 to 5 candidates for the Prime Minister's consideration, and will include an explanation as to how these individuals meet the statutory requirements and the assessment criteria. All candidates on the shortlist must be functionally bilingual, as confirmed through the objective assessment administered by the Office of the Commissioner of Federal Judicial Affairs. I will then consult on the shortlist of candidates with the Chief Justice of Canada, relevant provincial and territorial attorneys general, Cabinet colleagues, opposition critics, as well as members of this committee and the Senate Committee on Legal and Constitutional Affairs. The purposes of my consultations on the shortlist is to develop my recommendation to the Prime Minister as to who the government's choice should be. The Prime Minister and I anticipate that choosing from a list of eminently qualified jurists will be a difficult and humbling task, and we will greatly value your views. After the Prime Minister announces the government's nominee, I will appear with the chairperson of the Advisory Board before this committee to explain how the process unfolded and how our nominee meets the assessment criteria. The main purpose is to allow you, as parliamentarians, to hold the government to account for the manner in which the nominee has been selected. There will be a week between the announcement of the nominee and the hearing in order to give committee members time to prepare. In addition to this hearing, the nominee will take part in a question and answer session moderated by a law professor with members of this committee, the Senate Committee on Legal and Constitutional Affairs, and representatives from the Bloc Québécois and the Green Party. The Prime Minister will review and consider any views that the committee prior to making his final selection. Before concluding, I would like to briefly discuss the assessment criteria that will guide all decisions throughout this process. The assessment criteria relate to the skills, experience, and qualities candidates need to excel. The criteria also relate to the institutional needs of the Supreme Court. As I noted earlier, these criteria have been published on the website of the Office of the Commissioner for Federal Judicial Affairs. I encourage you to visit this website, given that the document in which the criteria are set out sets out the rationale for why each criteria has been included. Candidates will be assessed based on the following personal skills and experience: demonstrated superior knowledge of the law, superior analytical skills, ability to resolve complex legal problems, awareness of and the ability to synthesize information about the social context in which legal disputes arise, clarity of thought, particularly as demonstrated through written expression, the ability to work under significant time pressures requiring diligent review of voluminous materials in any area of law, and a commitment to public service. Applicants will also be assessed on the following personal qualities: irreproachable personal and professional integrity, respect and consideration for others, the ability to appreciate a diversity of views, perspectives, and life experiences, including those relating to groups, as I said, historically disadvantaged in Canadian society, moral courage, discretion, and open-mindedness. And finally, in carrying out their assessments, the Advisory Board will consider the following institutional needs of the Court: ensuring a reasonable balance between public and private law enterprise, bearing in mind the historic patterns of distribution between those areas in Supreme Court appeals, expertise in any specific subject matter that regularly features in appeals and is currently underrepresented on the Court, and ensuring that members of the Supreme Court are reasonably reflective of the diversity of Canadian society. The government is confident that the application process of these assessment criteria will lead to the identification of outstanding candidates for our highest court. And in conclusion, I wish to thank you again for coming here and convening today on this matter that is of the utmost importance to Canadians. And I look forward to appearing before you again on this same matter. And certainly, Mr. Chair, would be happy to take questions. And further to that, I would be happy to hear any perspectives or contributions that the members care to provide. Thank you.
Thank you very much, Madam Minister, for that very fulsome presentation. We very much appreciate your availability to come before us. And now we're going to move to the question period. So, members of the committee, we're going to do 2 rounds of questions. For those who are new to the committee, we're going to start with 6 minutes with the Conservatives, 6 minutes with the Liberals, 6 with the Conservative, 6 with the NDP, 6 with the Liberals, I think. Oh, 6 Conservative, 6 Liberal, 6 NDP, 6 Liberal. The second round will be 6 Liberal, 6 Conservative, 6 Liberal, 5 Conservative, 3 NDP. However, I tend to be flexible in terms of the questions if you're trying to get through a thought process and your questions are not designed for long-winded answers. And of course, if I see your time is being eaten up by the answer, I tend to be more flexible. Okay? So we're going to start with Mr. Nicholson. Mr. Nicholson, welcome. The floor is yours, sir.
Thank you very much, Mr. Chairman, and thank you, Minister, for appearing here today. And I think I join with all members of the committee in wishing our best wishes to retiring Justice Thomas Cromwell and wishing him all the best, and thanks for his service to the courts of this country. Minister, you talked about the list that will be considered by, and you indicated that there would be a judge on there or judges from Atlantic Canada, and you referred to the process by which judges from Atlantic Canada or from different parts of the country have been submitted and considered in the past. Now, you referred to it as a custom. Wouldn't you say that something that's been in place since 1875 is more than just a custom that could be more properly characterized as a constitutional convention, that Atlantic Canada will have one member of the Supreme Court of Canada, as it's allotted across the country? Wouldn't you say that's a constitutional convention?
Thank you for the question, and I would echo your comments with respect to the Honourable Justice Cromwell. Certainly, his service. It's fair to say that it is a convention. I recognize that regional representation has existed for over 100 years. There has been a point where that convention diverged, but recognize that for the regional representation has been reflected over 100 years.
So what you're saying is the person will not necessarily be from Atlantic Canada? Is that what you're saying to the committee?
The next appointment to the Supreme Court of Canada will not necessarily be a person from Atlantic Canada. Having said that, we recognize the importance of regional representation.
Well, just for the record, Mr. Chairman, I think that is a mistake. And again, these constitutional conventions have worked very well and over the years. But that being said, you've made yourself very, very clear on that regard. You indicated that the process that is in place now is outdated. It's not really that old, the process that was developed in the previous parliaments, which is to have members of parliament have a look at this. And wouldn't you say, Madam Justice, the Minister, that having elected members of Parliament means that there is a connection to the public of this country, that's a fair way to do that, and to turn this over to a committee that is not directly responsible to the public and not directly elected is less accountable than the process that has been in place.
Well, in terms of the process that the Prime Minister announced on August the 2nd, the intent to modernize the process or put in place a process is to ensure that we are open, that there is transparency, and that there are many levels of accountability in terms of the process that we as a government are going to employ in terms of appointing the next Supreme Court of Canada justice. Central to that, or the nucleus of this new appointment process, as you reference, is an independent advisory board. Our intent is to depoliticize the process and to provide eminent Canadians, the 7 that I mentioned in my comments, the ability to take an unprecedented step in opening up the application process for qualified jurists from across the country who are functionally bilingual and reflect the diversity, have the opportunity to put forward their applications for this most esteemed position. There are many steps, if we want to call them steps, in this process that will enable members of Parliament to be fundamentally involved as the process unfolds, and that process assures that members will have the ability to provide their input not only on the process but on the eventual nominee.
I don't know how they can be fundamentally a part of the process if they're not part of the process in selecting and coming up with the lists of judges. You say it increases the accountability if we take this away from members of Parliament, but who is more accountable than members of Parliament? This is a responsibility of Parliament, and in particular the Prime Minister, who is the first minister within Parliament to appoint judges to the Supreme Court. But if we take that ability away from members of Parliament to have a say in this, and again, this was a system that I think was widely well received among all political parties, how could it be possible that a group that does not have accountability to any of the electorate of this country be more accountable than members of Parliament?
Well, I would say in terms of the process, or as appointments have been made over the last 10 to 11 years, there wasn't any consistency between and among appointments that were made by previous governments with respect to the Supreme Court of Canada. I recognize back in 2004 with former Minister Kotler under Prime Minister Martin, there was attempts to move forward and quite successfully open up the process to provide further explanations as to the process and how candidates were selected in terms of being the nominee for the Supreme Court. In terms of being a part of the process, having an independent advisory board takes away the politics from ensuring that we can have as open and a transparent process that encourages qualified jurists from right across the country to be able to put their names forward to ensure that we have the best among us across the country as candidates that will be selected. In terms of members of Parliament being involved, members of Parliament today, I'm having a discussion, and there will be further discussions when I appear with the chair of the advisory board, as well as having discussions with the nominee, he or she, as it may be when that is named by the Prime Minister. And ultimately, the way that members of Parliament and all Canadians can have a role or part in this process is to ensure that if you know a jurist that meets the qualifications, to go out, seek and encourage them to put their names forward. That's the ultimate role that all of us as members of Parliament can play to ensure that there is a substantive list of qualified jurists.
It would be somewhat difficult if, we believe that Atlantic Canada should have the next appointment to the Supreme Court as to who we would give that advice to. Perhaps you could tell us what sort of a response did you get when you contacted the Attorneys General in Atlantic Canada with this new system, this new criteria, and the fact that the next Justice of the Supreme Court may not come from Atlantic Canada? Were they supportive of this? Were they indifferent, or did they express some concerns?
Well, I have had the opportunity on one or more occasions to speak with the Attorneys General of the Atlantic, and while I would like for most of our conversations to remain between the Attorneys General and myself, there were, but broadly speaking, there was a recognition that certainly an appointment from Atlantic Canada was a convention, as we've talked about, but there was a general reception, positive reception to opening up the process, to ensuring that there's clarity around how the process will unfold, appreciation of having conversations. And again, I encourage the Attorneys General to bring forward, encourage candidates that they know within their jurisdictions to apply for this esteemed position.
Thank you very much. Mr. Fraser.
Thank you very much, Mr. Chair, and I'd like to join my colleagues in thanking Mr. Justice Cromwell for his exemplary service on the Supreme Court of Canada. Merci beaucoup, Madame la Ministre, pour votre présence ici.
Thank you very much, Madam Minister, for being here with us at this committee today. I believe this is your fourth time appearing before the committee. And I'd also like to thank you for your work on this new process which we're discussing today.
Compliment the new process for the Independent Advisory Board. I agree with you that the process being more open and transparent, based on criteria that is known by the public, will serve Canadians well, and so I compliment the new process. Having said that, as a lawyer from Nova Scotia, and knowing the importance of regional representation on the Supreme Court of Canada and how that has played out in our past. I believe that that regional representation that is a custom has served us well as a country. And so I do have some concerns regarding what has already been discussed here today about not a certainty that the next appointment will be an Atlantic Canadian. I wonder then, given the fact that the seat is being vacated by Justice Cromwell, and that it is a long-standing custom that an Atlantic Canadian holds one seat, there's 2 from the West, 3 from Ontario, and 3 from Quebec by Constitution. Given that, what preferential weight will be given in the selection criteria for the next representative to be an Atlantic Canadian?
Well, thank you for the question, and I want to be clear and understand the importance of regional representation on the Supreme Court. In this process, we have made it very clear that regional representation is something fundamental that the advisory board should consider in assessing candidates. Likewise, we have, in terms of our government commitments, the next Supreme Court Justice and all members of the short list that's put together by the board must be functionally bilingual. We're also wanting and to ensure, and this is in the assessment criteria, that there is a reflection of diversity in terms of the candidates that are brought forward. And in the mandate letter that the Prime Minister wrote to former Prime Minister Kim Campbell, it states very clearly that on the short list of 3 to 5 candidates that there will be candidates from Atlantic Canada. So I, again, recognize that regional representation is important. So too is diversity. So too is ensuring that we have the most qualified jurist that will fill the vacancy of Justice Cromwell. And I have every expectation that there will be a significant number of qualified jurists from Atlantic Canada that will put their name forward.
Thank you very much. And I certainly concur that there are excellent jurists in Atlantic Canada, and no doubt we'll be well served by having their names on the short list for consideration. And I certainly encourage those people to submit their application to the new process so they can be considered. With regard to the Atlantic Canadian, if I can stay on that for a moment, Atlantic Canadian seat, if you will, on the Supreme Court of Canada, the Atlantic representation is considered, I think in the mandate letter it's mentioned that it's one factor to be considered. I'm wondering if there will be different weight apportioned to the different factors, or how do you see that playing out when making the decision on who the next Supreme Court nominee will be?
Well, I mean, as you quite rightly state, there are different criteria or factors for the advisory board to take into account. Certainly in my review of the shortlist and the consultations that I will take into account. Likewise, the Prime Minister, upon making the recommendation to the Governor and Council to officially appoint the next Supreme Court Justice. As we've talked about, regional representation is important and is a consideration, as is ensuring that we have a diversity of candidates that are brought forward reflective of Canadian society. And another important criteria that we have put in place and are committed to is having a functionally bilingual next Justice of the Supreme Court. And equally as important, underscoring the realities and highlighting the assessment criteria that are articulated publicly, that we have the most qualified candidate, meritorious candidate, and there's lots of different categories in terms of a breakdown of what merit actually means, that will represent as the next Justice of the Supreme Court. So there's a number of different criteria, as you rightly point out, all of which will be considered by the advisory board.
Okay, and one quick question. Thank you, Mr. Chair. Si je peux demander une question en français.
If I can ask a question in French. Madam Minister, could you compare the new appointment process for Supreme Court justices, which you explained today, to the process that was used last time there was a vacancy to fill at the Supreme Court? So would you be able to compare those two processes?
Well, just in terms of previous processes, they've been different in terms of every appointment that has been made to the Supreme Court of Canada. I can speak very confidently in the process that we're instituting as a government. The process that we're putting in place is to ensure that there's openness, that there's transparency, and that there are many levels of accountability built into the process to ensure that Canadians are provided with insight in terms of how the process will unfold and a better understanding in terms of how Supreme Court justices are appointed. We further, in terms of our process, are wanting to depoliticize the process, providing an independent advisory board with the ability to for the first time, open up the process of candidates putting their names forward and ensuring that the advisory board also has the ability to headhunt, if you will, or seek out people that would be qualified jurists. And one of the reasons, or the major reason why we're putting forward a new process is to ensure that it's publicly known. Previous processes were not articulated in this manner. So that's a pretty stark difference between what we're doing now and what happened in the past. And I want to underscore that's not to say that we do not have eminently qualified and jurists of the highest caliber and integrity on the Supreme Court of Canada, an institution that I'm sure we are all very proud of in terms of its integrity and the decisions that it renders.
Merci beaucoup, Monsieur Fraser. Monsieur Mulcair.
Thank you very much, Mr. Fraser. Now, Mr. Mulcair. Thank you, Mr. Chair. I'd like to welcome the Minister and thank her for being here today. Just to set up some context, I'd like to talk a little bit about the summer that we all just experienced as parliamentarians, because I think we're witnessing a problem that represents a real paradigm shift in the executive's attitude towards the legislative branch. Now, there was no discussion in Parliament about sending troops abroad, even though normally that's the convention. There were also discussions that happened within the Prime Minister's office with the parliamentary budget, the Director of Parliamentary Budgets. And, well, again, that's not really the convention. And, again, there was a letter which was given to just two newspapers, not all the newspapers, but it was given to the Globe and Mail and to La Presse, which is no longer published in paper format during the week. Now, I have tried to understand the legal aspects of what we're dealing with today. I looked at the Statutory Instruments Act. There's nothing about it there. There was a mention of publication in the Canada Gazette. But I'm trying to understand if this is a change in terms of substance from the Nadon affair, because that was declared ultra vires by the Parliament of Canada. As my colleague from the Conservative Party and the former Attorney General said, this 100-year-old convention of naming people from the Atlantic region cannot just be broken overnight, as though it weren't a big deal. So my first question for the Minister has to do with one of the first criteria she mentioned today. And in passing, I would like to thank the former member for Acadie-Bathurst, Yvon Gaudin, who fought very hard to make this one of the criteria for Supreme Court appointments. or who set a new criteria, which was the ability to read French and English. Now, this is the first time I've seen a completely new process for appointing Supreme Court judges in 9 years. Now, if the minister is sincere in her desire for having bilingual judges, why, when we know that Mr. Cromwell was going to leave, we've known that for the past year, why is this, why, if she really considers this to be an important criteria for Supreme Court appointments, why is she simply having this one piece of paper sent to 2 newspapers? Why didn't she use her powers with a majority in the House of Commons to have this embedded in the law? Why simply send out a press release to 2 newspapers?
Just thank you for the comments and the question. I think the question is with respect to bilingualism and disclosure of that criteria. We require in this process, which is the first time a process has been clearly articulated in advance of the appointment or the identification of a nominee, we require, it is a priority of our government, to have a Supreme Court of Canada justice be functionally bilingual, and the appointment of this government will ensure that the next appointment is functionally bilingual. As distinct from bilingual, there is a distinction between that. I believe what Mr. Mulcair is referring to is the letter that the Prime Minister had written and provided to newspapers. Recognize that that's an ability to be able to deliver a message, to highlight the new process. I was very pleased that day to be able to further answer questions on the new process and be available to all media in terms of answering and further describing the process that the Prime Minister articulated in those 2 articles that I believe my friend is referring to. But certainly in terms of the process, again, to underscore, this process is meant to be open and transparent and accountable, and that is the commitment that we will continue to maintain.
I know that those are the government's lines, but we do have other questions, Mr. Chairman. I wanted to now refer to an article that did appear in the Globe and Mail by Sean Fine, a very respected person who writes on the Supreme Court, and he explained that there was a committee of ministers that included both the minister who is here with us today and the government House leader. He explained that they were in the process of developing their own list, and I took good note of a sentence that the minister used in her opening remarks. She said, the committee will not take as its starting point a list from the government, but would it be fair to say that the government already has a pretty clear idea of what the ending point of this process should be? So I want to ask the minister to take this opportunity to explain exactly what this other process was that was taking place simultaneously prior to this unilateral announcement without involving Parliament.
Well, I thank the member for bringing up that question. And one of the things that I've learned as one of the new members of Parliament of October of 2015 is to not believe everything that one reads in the newspaper. And I will state it very clearly, is no alternative process. There is no committee of ministers comprised of myself and the House Leader or otherwise. This process and the start of a list has been handed over to an independent advisory board. This is the process that we're moving forward. Openness, transparency, and accountability are not talking points. This is the fundamental basis upon which this process must proceed and will proceed.
Thank you. One more short question, Mr. Mulcair.
Mr. Chair, in our parliamentary system of government, openness and transparency starts with a discussion with duly elected representatives of the public. Now, the minister contents herself, as she just said before, well, no, I'm talking to you now. but she is talking to us after they've already announced the result. So there's no consultation with Parliament. Let's be clear on that. This was decided in vacuo by members of Cabinet and simply sent as a letter to 2 chosen newspapers. And with regard to not believing everything that you read in a newspaper, that was in the Globe and Mail, and the Globe and Mail was indeed one of the only 2 newspapers to have received the Prime Minister's letter. One would have thought that that was an indication that the Minister thought that it was a worthwhile place to put that letter. So I don't know how you explain the difference between Sean Fine's article and what the Minister just said to us today. But I will say this, Mr. Chair, that right now we're looking at substantive changes, and if you go back to the Supreme Court's decision in Nadon, that this type of substantive change is not something that the executive branch of government can foist on parliamentarians who represent the legislative branch of government. That's a serious problem here, but it's also a consistent tendency of this new government, whether it was motion number 6, trying to take away all powers of the opposition, whether it was the Latvian deployment without any discussion in Parliament, despite the fact that the Liberals used to bemoan when the Conservatives would try to do that, they finally consulted Parliament, or direct talks between the PMO and the Parliamentary Budget Officer. It's not the Prime Minister's Budget Officer, it's Parliament's Budget Officer. And here, Parliament has always had a word to say, and I'm very concerned about the way we're trying to proceed here because we're being put before a fait accompli.
Okay.
This has already been decided in a vacuum by a small group of people, and the conclusions, as far as I'm concerned, as from what I've heard, are preordained. Thank you, Mr. Chair.
Madam Minister, I think you might want to respond.
Well, I obviously disagree with what has been put forward. This process is not preordained. There are not any predeterminations, to say it a different way. What we have sought to do is to describe in what I think is great detail how this process is going to unfold. And in terms of having members of Parliament involved in the process, I articulated that in my speaking points and again in answering other questions. Not only today is there an opportunity for people to be members of Parliament to be involved, but there are other opportunities in this process. And I will just say in closing, there was no process last time. What we have sought to do is clearly provide members a process and how an understanding of the process and how through that process Supreme Court of Canada justices will be appointed. This is, in my view, a good news story that invites Canadians into understanding how Supreme Court justices, like Minister Kotler did in 2004, invite Canadians into having discussions about this fundamental institution of our democracy and an understanding of the people that fill these seats.
Thank you very much. Mr. Biddle.
Minister, I wanted to thank you for the opportunity to discuss these issues. The honourable member from Outremont suggests that this is a fundamental change to the way in Supreme Court justices are selected, but at the end of the day, it will be the Prime Minister who makes the selection, as has been the case going forward. Wouldn't you agree, though, that this is just a matter of opening up an opaque process that has existed for far too long and continuing with our commitment for openness and transparency?
I agree with that proposition, and again, I'm very happy to further explain parts of the process, to hear feedback on the process, recognize within the process there's the opportunity for this committee to provide feedback on the process, on the nominee, and other matters in terms of their selection. What we have described in the process is not a formal change by way of legislation or the Constitution. This is a matter of policy and priority that our government is putting forward, whether it be around functional bilingualism or around the recognition that diversity is important to the Supreme Court of Canada. So I'm really pleased to be here to talk about this process and would invite you, Mr. Biddle, and others to comment on it.
Thank you so much, Minister. It's a structural issue, but the pool of judges that the panel will be able to select from will predominantly be white and male, given that I believe only about 30 to 35% of judges in Canada are women. does the requirement that judges be bilingual limit the ability to appoint more women, minorities, and Indigenous people to the top court?
Well, just on your initial comments, I'm not sure if you intended it this way. The eligibility criteria as articulated in the Supreme Court Act enables current sitting justices in terms of, leaving aside the province of Quebec, in Section 5, current sitting justices or former justices or jurists that have been called to the bar of their jurisdiction for over 10 years. So it's not just limited to judges, but to jurists of the highest quality. I have been asked that question around whether or not the requirement of a functionally bilingual candidate would limit the pool. I have every confidence that there are eminently qualified jurists, whether they are Indigenous or a visible minority or persons with disabilities, have the ability to put their names forward and that they exist across the country.
Would the government be prepared to appoint an exceptional candidate, such as an Indigenous judge, a person with a disability, individual with a visible minority, on the condition that they learn English or French and become functionally bilingual?
Well, our commitment as a government is to ensure that the appointment of the next Justice of the Supreme Court is functionally bilingual. I know that there has been discussions in the past with respect to previous appointments around learning to be or French or English, as the case may be. But in this case, our commitment is to ensure that there is a functionally bilingual justice that's appointed to the Supreme Court. And again, I recognize that if we're talking about the Indigenous population, that there are eminent scholars, lawyers, as well as judges that have equal ability to put their names forward.
I think we can all agree that Supreme Court judges should be persons of exemplary character. Even though there are lawyers who have been appointed, I believe there's been, 3, I could be wrong on that point in our history, it's typically judges. And it can be difficult to determine a judge's character because as a judge, they have to separate themselves from the community, from their community. Is the committee going to look beyond a judge's decisions, and will they look to what these individuals did as lawyers, as part of their community and the work they did within their communities?
I think that's a great question, and recognize that judges are human beings, and as human beings bring a wealth of experience and background to the positions that they hold or potentially could hold. One of main reason why the qualifications and the assessment criteria that we've set out is made publicly available is so that individual Canadians, members of parliament or otherwise have the ability to understand the basis upon which candidates will be assessed by the advisory board. Certainly there is a recognition to having a firm understanding of the law, significant analytical abilities, as I said in my remarks, and also recognition of personal qualities that are of paramount to the assessment criteria, looking at diversity, looking at what the individual did in their previous capacities. And I think central to the assessment criteria or the work of the advisory board will be the questionnaire that we have compiled, also available online, that asks a significant number of questions of potential jurists that want to put their names forward, that will not only for the advisory board provide insight into the individuals and their thought process potentially, but also be made available specifically questions with respect to the nominee that will be announced.
Thank you very much. We're now going to go into the second round of questions. So just to remind everyone, this round goes Liberal, Conservative, NDP. So this round is going to be started by Ms. Vanden Belde. Ms. Vanden Belde.
Thank you very much, Mr. Chair, and I will be sharing my time with Mr. McKinnon. Thank you, Minister, for being here today and for listening to the views of parliamentarians, and it's a tremendous pleasure for me to be able to be part of this conversation. I'd like to talk a little bit about the appointment of women to the court. We know, and there's been ample evidence, that when a deliberative body has both women and men on it, you do see better decision making. And if you look at the jurisprudence of the Supreme Court and you look at the opinions that have been given by the female justices, you see some of that change in discourse, particularly around Section 15 of the Charter. And so my question to you is, you've spoken quite a bit about the diversity of backgrounds, life experiences. I agree that the definition of merit also ensures that the person can understand the societal implications and the diverse experiences that will bring people before the court. Madame la Ministre, il y a ici au Canada.
Madam Minister, here in Canada, there are more and more women who are becoming lawyers, more and more women becoming judges, but at the level of the Supreme Court, things are different. The numbers went up a little bit, and then they went down, and then they went up again, and there are currently 4 women sitting at the Supreme Court. So how can we ensure that the new process will lead to gender equality at the Supreme Court?
Well, thank you for the question and for being part of this committee. I, without question, recognize the importance of gender parity, and further going back into the early 1980s, 82, with the appointment of Justice Bertha Wilson as the first woman to the Supreme Court of Canada. A lot has changed since then, and as you quite rightly point out, there currently are, with the retirement of the Honourable Justice Cromwell, there will be 4 women and 4 men on the court. The Chief Justice, obviously, being Madam Justice McLaughlin. Like a recognition of the need for diversity in terms of unrepresented communities, there is a need to look and ensure that there is representation of men and women. Given the nature, the composition of the Supreme Court being 9 justices, we won't have parity ever at the Supreme Court of Canada, at least under this current time, but I think your point is well taken in ensuring that there is a recognition of the need for gender parity.
So it is your expectation that the shortlist will include multiple women on that list?
Well, I like having candidates from Atlantic Canada. I suspect and know that there are equal number of eminent jurists that are of the female persuasion as there are men.
Thank you very much.
Finish the time on this round?
Okay. Minister, the process you've outlined attempts to strike a balance between parliamentary involvement and the involvement of external nonpartisan inputs in the process. And I'd like to delve a little further into the role that this committee will play in that process. And I would like to thank you as well for being here as part of that involvement. So my understanding is that the external committee will basically filter through the list of applicants and come up with a short list of candidates based on their the application of the criteria. So what then will this committee do when you consult with this committee? Do we further shortlist that list, or perhaps you could just expound on that a bit?
Sorry, just for clarification, when I consult with this committee?
Yes.
Okay. In terms of the Independent Advisory Board, you quite rightly point out that they will intake through an open application process candidates, qualified candidates, and have the ability to seek out other qualified candidates to put their names forward. What the Prime Minister has done in terms of the mandate letter as well as the terms of reference is tasked the board with the duties to look at the assessment criteria that has been articulated and come up with a short list of 3 to 5 names. Once the committee has come up with a short list of 3 to 5 names, that is the point at which I will take the list and engage in a series of consultations. Certainly, as I stated, with the Supreme Court Chief Justice McLachlin, I will have discussions with the relevant attorneys general on the short list. I will have conversations with justice critics, and we'll have discussions with members of this committee and the Senate Committee on Constitutional and Legal Affairs, ensuring that I am able to, based on discussions, and ensuring that I recognize the balance that needs to be drawn between transparency and the necessary realities of privacy and the protection of privacy in terms of individuals that will be on that short list. But I look forward to having those fulsome discussions and ensuring that the recommendation that I make to the Prime Minister is based on those discussions in terms of the shortlist.
Thank you very much. Mr. Cooper?
Thank you, Mr. Chair, and thank you, Madam Minister, for being here and for your presentation. Before I ask some questions about the process that your government has unveiled with respect to Supreme Court appointments, I do have one question that I do want to ask in light of the comments that were made by Chief Justice McLachlin, as reported in the Ottawa Citizen, about the fact that we have in Canada 44 judicial vacancies and the negative impact that this is having on the administration of justice across Canada, whether you have appointed, as of today, a judicial affairs advisor.
Well,
Question may be slightly out of the scope of the nature of the presentation of the minister. So I'm just wondering, Mr. Cooper, is that the only question that you're going to have that's going to go outside the scope?
That's correct.
Okay, so Madam Minister, it's up to you if you want to respond.
I'm happy to respond to the question, and certainly thank Mr. Cooper for the question and his diligence in terms of raising the issue of judicial appointments on an ongoing basis. As I've indicated previously and will continue to do so, we have made, as you point out, appointments, recognize the vacancies that exist, and are working diligently to fill those vacancies based on a new process, much the same as what has been articulated here in terms of the Supreme Court, a process that will embrace diversity and again will be to ensure that the justices reflect the diversity of the country. In terms of your specific question on a judicial affairs advisor, we in my office are supported by a significant number of individuals that have assisted in the previous appointments. It is my intention to have a judicial affairs advisor in place in due course.
Thank you, Madam Minister, for that answer. Now turning to the substance of why you are here today, in terms of the process that your government has unveiled, I have to admit I have some concerns with it. One of the concerns that I have is with respect to the fact that the process does not respect the long-standing constitutional convention of ensuring that Atlantic Canada have at least one seat on the Supreme Court, a convention that dates back more than 100 years. And I was wondering if you might be able to comment on what authority the executive has to unilaterally overturn a constitutional convention, the effect of which will change the composition of the court unilaterally without the consent of Parliament and without the consent of the provinces as provided for in Section 41 sub D of the Constitution Act of 1982.
Well, thank you for the question, and again, focusing on regional representation, I will underscore that regional representation is a important consideration criteria for this process, and we recognize, as I said earlier, that this appointment process does not preclude an appointment from Atlantic Canada, and that the Prime Minister has, based on the policies and the approach to ensure that other criteria like diversity, like ensuring that we have a deep pool of qualified jurists in terms that would provide a deep pool of qualified jurists to the advisory board for their consideration is available. That is not to say that regional representation is not important, and recognize that there will be candidates from the Atlantic on the short list that is provided to the Prime Minister.
Well, thank you, Minister, and I certainly agree that it's diversity and all of those things are important. And I also acknowledge that you've said that Atlantic Canada would not necessarily be precluded, but you've also, in so saying that the government may appoint someone other than an Atlantic Canadian. And I want to get back to the question of what authority the executive of the government has to do that unilaterally. And to that end, I would just draw your attention to paragraph 74 of the Nadon decision, and I'll just read it. It says, quote, Parliament cannot unilaterally change the, so in this case it's not even Parliament, it's the executive, unilaterally change the composition of the Supreme Court of Canada. Essential features of the court are constitutionally protected under Part 5 of the Constitution Act 1982. Changes to the composition of the court can only be made under the procedure provided in Section 41, which again requires consent of Parliament and the consent of all 10 provinces. So I guess I'd like perhaps if you could perhaps clarify, in light of that, in light of the clear pronouncement of the Supreme Court in Nadon, what authority the executive has to unilaterally overturn this constitutional convention related to the composition of the court.
Well, I appreciate you reading out that excerpt from the Nadon decision and recognize that the amending formula to change the composition of the Supreme Court of Canada is unilateral. In terms of regional representation, again, I will underscore that we are not precluding having an Atlantic candidate as the next Supreme Court of Canada justice. It is not without precedent to diverge away from the regional appointments. Having said that, regional representation, functional bilingualism, diversity in particular are very important criteria, and ensuring that we have qualified jurists that put their names forward so we can make the appointment based on a significant pool of candidates is the approach, is the policy that this government is moving forward with.
Thank you very much. Ms. Khalid?
Thank you, Chair. And thank you, Madam Minister, for coming in today to speak to us about this very important process that the government has unveiled. I just want to bring to light that we've had a very, I think, the first time in the history of Canada, the most diverse government or parliamentarians in general that have been elected. I myself am currently the only visible minority in the room, and in general, I'm the only woman that sits on this Standing Committee of Justice. So I understand how difficult it is to truly reflect diversity. With respect to the Supreme Court, now I understand that this one seat that is looking to be filled, I can't really accommodate for all the diversity that we are looking for, but I would like to know how are we going to go about ensuring that that people are represented through this election process, not just this time, but also going forward.
Well, thank you for the comments and the question. Again, diversity is an important criteria. What we have sought to do in terms of this selection process is make our assessment criteria public in terms of this appointment and future appointments to the Supreme Court of Canada. The next one, barring any other circumstances, will be in 2018 when the Chief Justice is set to retire at age 75. But it's the intention to ensure that this process is followed for this appointment and future appointments, and recognize that built into this process is the ability for members of Parliament, the Advisory Board and others to contribute and comments about how we can improve the process. We talked earlier about the first woman that was appointed to the Supreme Court of Canada, and so the social realities of our country and what it means to be Canadian and is a dynamic process. I believe that a recognition of the need for diversity on the Supreme Court of Canada publicly is a substantive start to the process and the acknowledgement of the need to ensure that as we move forward, we have the highest court in our land reflective of the diversity that exists in the country. Who the appointment will be is yet to be determined, as I've said. I don't think that you're the only visible minority around this table. I too come from a visible minority and am very proud of it. And I know that among the visible minorities in this country, there are substantive jurists that can put their name forward this time and in the future, and recognize that when as we move towards having a more diverse bench, not only at the Supreme Court, but other courts in the country, it not only provides differing perspectives and backgrounds and considerations in terms of legal concepts and cases and factual circumstances, but it also provides an increased sense of confidence in the judiciary, in that people that appear before the justices have the confidence that they see the reflection in them.
Thank you for that. I just also want to note, we've talked a lot about functional bilingualism today, and I just want to point out that 13 out of the 15 of our past appointments have been functionally bilingual, even though it's not been a requirement. So we've had a very good process. I want to talk a little bit about Quebec. The process that's been announced says that it will be varied somewhat for one of the 3 seats that are reserved for Quebec. Can you provide some more precise information on how the process will be varied for that one Quebec appointment?
3 seats. I think we need 3 seats reserved for Quebec on the civil law appointments.
Well, constitutionally, there's a requirement for 3 jurists on the Supreme Court of Canada to be from Quebec, given its unique legal traditions in civil law. I'll say this and recognize that of the 3 Quebec jurists on the Supreme Court, or justices on the Supreme Court of Canada, the next one, according to the timeline, will be up for retirement in 2032. So there is some time to consider appointments, recognizing that circumstances as they may be might make that sooner. However, in terms of the appointment process and what considerations would be made in terms of the composition of the advisory board, again, there's the recognition that there is a unique legal tradition in Quebec, and while there is no specific determination of the composition, as the case may be for the appointment of a Quebec justice to the Supreme Court of Canada, it would be in recognition of that unique tradition and potentially additional members that would be on the advisory board from the province of Quebec. But that is something that is to be determined in a substantive way. But I think in terms of this process, the recognition that there needs to be a distinction in terms of appointments from Quebec, recognizing their unique constitutional realities and their legal system is important.
You have time for one more short question?
Thank you. No, it's great to see that the proposed nomination process has received widespread approval from editorial boards such as the Montreal Gazette and columnists and professors across the political spectrum who have judged it to be an improvement from and more transparent than the previous process. Now, how did the government select its 3 nominees on the advisory panel, and will this panel remain in place for future appointments as well?
Well, thank you for the question. And in terms of the 3 government appointees to the advisory board, it's in the mandate letter from the Prime Minister to the chair and the members that their terms will be for 6 months. The order in council says that terms will be for up to 5 years. So in terms of how the government identified its candidates, I think without reservation, a recognition of former Prime Minister Kim Campbell, her contributions as the Prime Minister, as holding down various portfolios in terms of being a Minister of the Crown, her contributions to our country post-public life are very well known, and I very much appreciate seeing the positive responses to her appointment and hold her in the highest regard. In terms of the other 2 government members, both of which are non-lawyers, and specifically these are eminent Canadians that in their own right have contributed to the fabric of our country in substantive ways. One being a former Premier of the Northwest Territories, and as I said, has contributed to his nation and reconciliation with Indigenous peoples, brings that perspective. The other has a substantive amount of work in her community, and that work and the work of Stephen is reflective of the commitment we have to diversity and the recognition that non-legal members are important to provide perspectives in terms of their various background and contribute to discussions around the assessment criteria.
Thank you very much. And now Mr. Nicholson and Mr. Schmale will share this time. Mr. Nicholson.
Thank you very much. Thank you for your comments, Minister, with respect to Atlantic Canada and the importance that be a part of the consideration. I just have one question in that. If it is important, it's important to the Prime Minister and it's important to you, why wouldn't that have been listed as one of the criteria? I mean, you've got a list of criteria that are important and functionally bilingual, of course, and representing the diversity of the country. Why wouldn't, whether the person comes from Atlantic Canada, why wouldn't that have been mentioned in the criteria at this point in time?
Well, in the mandate letter from the Prime Minister to the advisory board is the recognition and the need to have candidates on the short list of 3 to 5 be from Atlantic Canada.
Let me ask you this. You said that you're going to replicate the system that you're putting in place for the Supreme Court nominees. You're going to replicate that across the Canada for Superior Court judges. Did I get that right?
What I meant when I may have misspoken, we are intending, in terms of the question that was asked about appointments to superior courts, we are intending to reconstitute the process by which superior court justices are appointed. And when I said replicating, ensuring that there is diversity in terms of the appointments and that there's an ability to reach out into the legal community to identify jurists that potentially would not normally be identified, to ensure that, for example, underrepresented persons would have the ability to sit as superior court justices to transform the look of the bench.
How soon do you think that this process is going to be put in place? I mean, you must be concerned by the delays in getting appointments done, and you must be considerably concerned by the comments of the Chief Justice of the Supreme Court with respect to over 40 judicial appointments. I mean, you've been in office now about 10 months now. It seems to me that some process has to get in place. And what is the problem with going forward on this? And are you as concerned as I'm sure I guess you would be to hear from the Chief Justice on the challenges that they're facing with all these vacancies?
Well, I appreciate the question. I know this is beyond the scope of the Supreme Court of Canada appointment, but I'm happy to respond. And I always take very seriously comments made by the Supreme Court of Canada Chief Justice. And I take very seriously as well comments that are made around this table and in Parliament. We are moving forward. We have appointed a number of justices, and we are moving forward with renovating the process by which justices will be identified, and in doing so recognize that we need to fill vacancies, and we are endeavoring to do that in a thoughtful, comprehensive way that achieves the objectives that we have very publicly stated in terms of appointments of justices that reflect the diversity of the country.
Thank you, Mr. Chair. Thank you, Minister, for being here today. My time is short, so I do apologize. Being that you said 3 out of 5 of the potential candidates for the Supreme Court nomination be from Atlantic Canada, that may or may not be chosen by the Prime Minister at the end of the day. Are you okay if that vacancy goes to someone in Quebec or Ontario or other parts of the country, and say give Ontario 4 of those seats and not have anyone from Atlantic Canada represented?
Well, just to clarify, I didn't say that 3 of the 5 candidates would be from Atlantic Canada. What I did say, and what our process, or the letter from the Prime Minister articulates, is that there will be candidates on the shortlist from Atlantic Canada.
Okay, but
because what she said.
Okay,
that's where
I
you got
apologize
confused.
if I wrote down my notes wrong. I do apologize, but. If the seat does go to someone from Quebec, Ontario, you're okay with nobody from being Atlantic Canada represented on the Supreme Court?
Well, I'm looking forward to our process unfolding. I'm certainly looking forward to the assessments that the Independent Advisory Board will make with respect to the candidates that put their names forward. As part of this process, I will have the opportunity, as I indicated, to consult on the short list, and that includes with Attorneys General of the relevant jurisdictions. And I know and am confident that the shortlist that is presented will reflect substantive jurists of the highest quality that are functionally bilingual, and as much as we can reflect diversity. So I look forward to seeing that shortlist and doing the work that I am required in this really important process.
Okay, I think we do all agree, and thank you, Minister. We all agree that diversity and showing inclusiveness across the country is very important on the Supreme Court. And it was brought up earlier by Mr. Biddle, and I would like to ask you again about that. Are you worried about what the condition that the candidate be fully bilingual? Do you think that may hurt a potential candidate from Newfoundland and Labrador, possibly Prince Edward Island, from being nominated, or at least making it through the selection process? Because Mr. Biddle did point out that could it not be adjusted to say, and if I apologize, but it would be a qualification that that candidate, he or she, then take the courses necessary so that you don't rule out a section of the population.
Well, I appreciate the follow-up on the question, and to restate, it's our commitment that the next justice that's appointed to the Supreme Court of Canada will be functionally bilingual, and when I say functionally bilingual, will have the ability to understand oral and written arguments. That's not to say that the candidate will have to be able to engage counsel in both languages, although that's a positive attribute that a candidate can bring forward. But in terms of limiting the pool of candidates in terms of the appointment process, I am confident that there are jurists across the country in every jurisdiction that will meet the criteria as ascribed in our public process, and I encourage all of those individuals to apply.
Thank you very much. Mr. Mulcair?
Alors, c'est une excellente entrée en matière pour ma prochaine
I think that sets the scene perfectly for my next series of questions, Mr. Chair, because I wanted to know exactly what the word functionally means in functionally bilingual. Looking at the documents, it says that justice would have to be functionally bilingual, but my colleague, Mr. Schmale, was talking about total bilingualism, and the minister said, no, the person just needs to be able to read the documents, understand the arguments, but not necessarily speak the language. Now, I'm trying to understand what this means, and looked at various government information that was issued. And I found this statement by Joel Lightbound in the media, who said that perhaps there should be a test for justices. So does the minister agree that in order to prove that you are functionally bilingual, there should be a test? Would that be part of your plan, or is that just Mr. Lightbound's idea?
Well, thank you for the question. I haven't seen the article of which you refer, but it will be the responsibility of the Office of Federal Judicial Affairs to determine the assessment of bilingualism in terms of the candidates that are on the short, or the nominee that is announced.
Again, Mr. Chair, it's been a long time since we've been pushing for this criterion to be there, that you have to be bilingual, and Yvon Godin worked very hard on this. And one of the reasons was, I remember, she's an extraordinary Chief Justice, but I remember Chief Justice McLaughlin looking down at a lawyer who had been pleading in French and asking him to slow down, because one of the judges, and she named him, didn't understand any French. But since we both know that everything's timed in the Supreme Court, what that means is that there's an objective disadvantage to someone who's being told to slow down, so that the translation can catch up. But I don't think we've got an answer yet, because Mr. Schmale's question and mine are similar, because I'd really like to be able to answer people when they ask me that question. What does it mean to be functionally bilingual? The documents that have been put out by the government say it would be an asset, like you used to see in bilingualism an asset, which usually meant it didn't really matter. Now the minister just used the term positive attribute, if you can actually speak the language. Because it's hard to understand how somebody can be functionally bilingual if they can't speak a language. So maybe the minister could help us understand what that criterion is, because I've worked in this area for decades now. I can tell you what the criteria are under the Charter of the French Language for members of professional orders, but I don't know what that means. So maybe the minister can tell us what that means to be functionally bilingual, and what it is that might be tested, because that's what one of our MPs has said, that there might be a test associated with that.
In terms of functional bilingualism, it is a requirement for a justice to be able to understand oral and written arguments without the aid of an interpreter. A recognition, and what I referenced before, was the ability of the justice to engage in conversations with counsel is not required, but would be certainly a beneficial attribute of an individual wanting to put their names forward.
Juste pour être sûr que tout le monde est sur la même.
Just to be sure that everyone's on the same page and everyone understands correctly, I believe the minister just explained that a justice might meet the criteria of being functionally bilingual, even if, in reality, he or she doesn't speak the language. So they may claim to read and understand the language, but not speak it. And according to those criteria, the person would be called functionally bilingual. Because I've never heard this word effectivement in French or functionally in English in this context. And so basically, even if the person does not speak the language, they could be called functionally bilingual.
Well, I've articulated what functionally bilingualism means, and the assessment will be developed in the Office of the Federal Judicial Affairs.
Mr. Mulcair?
What does that mean, the assessment will be developed in the Office of Federal Judicial Affairs? What does that mean?
In terms of the...
It's going to be a test?
Sorry?
Is it going to be a test?
That will be something for the office to determine, to be conclusive that the candidate that is being brought forward is functionally bilingual. And again, functionally bilingual meaning that the justice has the ability to understand oral and written arguments without the aid of an interpreter.
So one last question, Mr. Mulcair.
No, it's a remark and it's a compliment to the minister and the government on one very specific point: the insistence on representation of the broad diversity of Canadian society is something with which we are in full agreement and about which we applaud the government.
Thank you very much, Mr. Mulcair, and thank you very much to all the members of your committee for your very profound and incisive questions. And thank you very much to the minister for your very clear presentation and you taking so much time with the committee to answer our questions. Thank you very much.
Thank you.
And now, ladies and gentlemen of the committee, I don't have anything else on the agenda today. Does anyone else have anything they want to raise before we adjourn? If not, meeting adjourned. Thank you very much, everybody.